Good afternoon, I'm your host, Brian Buckmeyer, here at the Law&Crime Trial Network. Now we are continuing on the case out of Ohio with Skylar Richardson. We're going to go right into court where the prosecution is doing the redirect with a pathologist. So here we are watching the Richardson case out of Ohio. We're seeing this forensic pathologist kind of being cross-examined, recross, redirect. We're here with Joseph Tully. How you doing today, Joseph?
I'm doing well. How are you?
Good, thank you. Now, I think for most of us here in the studio, we become quite fans of the defense here, partly because of what we perceive to be a lack of evidence for the prosecution, especially as to the intent and the method of the death, but also as to the style and kind of the poise of these defense attorneys. As we're looking at this redirect and the cross-examination and then the recross-examination, what are you gathering here from the forensic pathologist?
Well, firstly, I'm gathering that the defense attorney is very much at ease, very much at home, and that conveys to the jury that he's confident in his case. And he's using that confidence to really systematically take down the prosecution's key witness.
Yeah, he's cross-examining him again. Let's go back into court to see what he has to say. So we're just going to pop out of court for a moment while we're getting a new witness. As you heard there, the judge says we're going to be getting testimony for the next 30 minutes before we get to lunch. So let's talk a little bit while we have the time. Joseph, I know that this is just a forensic pathologist, and I don't mean just to mean demeaning, but there's a lot of questions that kind of went outside of the scope of her job title, which she could have known. What do you gather as to why both sides are doing that?
Well, the defense is trying to score their points. They're trying to score their points that the prosecution's case was, half-cooked, that they don't have all the facts, and that there was a rush to judgment. And so by asking questions that are outside that witness's scope, you highlight to the jury the fact that this witness really has nothing valuable to offer in terms of the key core evidence in this case.
Yeah, because we heard questions about, did you see any tampons or any blood here or there? I mean, it's obviously not a part of her investigation, but I think to your point, Joseph, it is scoring points in some way, shape, or form. Do you think this could be a case where we're just saying, hey, this is a botched investigation, this is a rush to judgment, and here you have this poor young girl at the mercy of the government prosecuting her for basically a miscarriage?
I don't think anybody could say it any better than that. I think that's a perfect summation of the defense's case in this case.
Yeah. Now, we have a new witness on the stand. She's only going to be here for about 30 minutes, so let's jump into court to see what she has to say. So it appears that the court is going down for its lunch break. We anticipate that we'll be back in about an hour, hour and a half, depending on how long that break is. So we're going to continue to analogize this case. Joseph Tully, it seems like the defense was pretty in and out with these questions, which I know at least I applaud and I like. I'm not sure how you felt, but he went right to the heart of the question. Does any of this show homicide? Was there anything else that needs to be asked?
Yes, sir. I mean, there's a legal maxim, and I'm sure you've heard it in court, and I've heard it in court. A judge will say, be surgeons, not butchers. And so the fact that the defense is going right to the heart of the issue and getting in and getting out is actually A+ work.
Yeah, I know oftentimes in law school they give you an acronym because they always give you acronyms. It was KISS. It was keep it simple, stupid. You just want to give a little bit of a kiss in your cross-examination. And I think for that's what would happen. I mean, what else do you need to get out of the pathologist? They did it before in the last witness where they were getting all of those kind of ancillary concepts in, like, hey, does this show anything? Does this show anything? But it was in and out. And I think, at least for me, Joseph, what I'm always thinking about when I'm asking witness around this time is people want to eat. They want to go to lunch. So if you can be the lawyer that everyone likes and say, hey, this guy got us out to lunch quicker, sometimes it's a bit of a popularity contest, and that could help.
Sure, yeah. Sometimes you certainly want to show the jury that you're aware, that you're in command, and you are going to take care of them. If they need to look for somebody for answers in the courtroom, look to me because I know what's going on, and I'll take care of you. It's certainly something that you want to do. However, another thing, a good point is that information is like inflation. Inflation is bad because the more dollars that are out in circulation, the less valuable each one becomes. And so the more questions you have out there, it kind of dilutes your main point. So by keeping it simple and going straight to the point, you're really just highlighting your case to the jury over and over without getting washed in information inflation, as I like to call it.
Yeah, and also it allows for the defense to kind of control the storyline, because if they went and asked a bunch of questions, then it becomes a little gray. Then the witness gets to explain and kind of expand on this concept or another. But if you come in and out and you get to come in summation and say, hey, this witness took the stand, I asked 2 questions, and at the end of the day, the witness said, I can't tell if it's a homicide. And I know to your point, you said it during the break, the ultimate question is homicide. Was this intentional? And these witnesses aren't giving what the prosecution really needs.
Exactly. I mean, some of the answers that the witness gave to the prosecution on direct establish reasonable doubt.
Yeah, it's weird that oftentimes a prosecutor's questions will leave you saying, oh man, it's really an uphill battle. But to your point, Joseph, I hear the prosecution go, and I'm like, I hear reasonable doubt. Then I hear the defense go, and I hear more reasonable doubt. So it kind of begs the question, this doesn't seem like a reasonable case if there's so many doubts. But Joseph, continue, sorry.
Oh, no. Yeah, it happens a lot more than most people realize. Like sometimes as a defense attorney, you think, why is the prosecution pushing this case? And sometimes we have to call their bluff and say, look, you don't have a case. I'm going to go to trial. And yeah, it's scary. Yeah, my client's life is on the line, but they didn't do it, and I'm going to call your bluff. And sometimes cases do fall apart in trial for the prosecution.
And let's see if this bluff called by the defense is an appropriate one, and if it works out in the end. We're going to continue to follow this case and more out of Ohio after this break.